now. So, excuse me, let me go ahead and get started. And it's only 10 slides, so this is really not bad. So we're just going over basically some of the court system. It's, like I said, really not bad. Let me get my participants list over here so I can have them, and I can have the chat in case somebody needs to say something. Okay, cool. All right, so we're understanding the court system and trial procedures. Literally, okay, guys, I'm gonna just vent for a second. They're doing construction apparently, like right next to my room. So if I lose my train of thought or you hear something very loud, that's what it is. But what irritates me is third period is my planning, and I haven't heard them do anything during third period. But they did all through first and second, and now they're doing it fourth. But okay, I just had to vent about that really quickly. Okay. So the federal courts, we kind of talked about this already, but we're going to go through it again now in more detail. So the U.S. Supreme Court has both original and appellate jurisdiction. The U.S. Court of Appeals has appellate jurisdiction over the district courts, and the U.S. District Courts is the lowest level of federal court with general jurisdiction. U.S. District Courts have an original jurisdiction over most federal court cases. If you remember that video, or you had to go back and watch that video, I don't know if you did or not. The video from what's the channel? I lost the name. It's got little animations, and the guy John Green or something is his name. He's usually the one in it. But anyway, we watched that video, and it really did a good job of talking about these district courts. So if you didn't watch that, you might want to go back over it because it honestly just kind of goes through it very easily. So let's go over the NC State courts. NC Supreme Court, state's highest court, and it questions the law of North Carolina. NC Court of Appeals is the immediate appellate court that decides only questions of law. And then NC Superior Court made up of two divisions, Superior and District. And we're going to go over that. North Carolina court system is a little weird and different, but it makes sense. Like, you know, from the outside looking in, it looks weird. But when you're inside of that world, it makes a lot of sense. And it helps the flow of kind of court systems go better, in my opinion. But we'll talk about that in a moment. So going farther into that, so the NC District Courts hold trials to determine the facts of cases divided into magistrates court, civil court, criminal court, and juvenile court. Trial procedures in a criminal case. So first, an arrest has to be made in a criminal case. Make sure you remember that. In a criminal case, there is an arrest. So a person who has allegedly committed a felony, because they're not guilty yet, because you're innocent until proven guilty. So yes, it's an alleged felon, and they've committed a felony offense or a serious misdemeanor offense that does not meet the requirements for a person to be released on a signature summons. So then the initial bail is set. The magistrate sets an initial bail bond amount in order for the person charged to be released after the arrested person is taken before a magistrate. You might not get bail depending on, you know, your flight risk, what kind of crime did you commit. If you are, you know, being charged with killing a whole bunch of people and you are a flight risk, they're not going to really give you a bail. And if they do, it'll be so significantly high that no one really could pay. Arraignment/initial hearing. So the charged person is brought before a judge to determine the probable cause and set any bail requirements. So then you go to grand jury, panel of 18 randomly selected citizens for a trial to determine if probable cause exists for the case to go to trial. So they're going to decide if it even needs to go to trial. You know, did they pick you up out of nowhere and say that you committed this crime and there's no way that that's possibly you? Then you might, you know, not even see a courtroom over it. But if there's any kind of probable cause, you're probably going to court over it. So let's talk about a civil case. So there's got to be a complaint. So a person or entity bringing or filing the lawsuit. So obviously you've done something wrong, but it has to be something that's not really a felony. So this could be trespassing. This could be, you know, I went into my neighbor's yard and I cut down their tree, and that's the complaint. The defendant person or entity against which the lawsuit is brought. Then there's the complaint itself, the initial pleading. So in that instance about the tree, I just said, if I was the one who cut down the tree, I'm the defendant, and the complainant is my neighbor who owned the tree. The complaint is that I cut down his tree. And then the answer is a response to a civil complaint. And then there's a summons, official notice of the lawsuit that is issued by the clerk of court. So they're going to come to my house and say, you're being summoned to go to court because you cut down your neighbor's tree, so we're going to court over it. Pleadings are the papers requesting something or responding to a request that are filed in the case, including the complaint and answer. If we continue with criminal and civil, this is kind of, they both work this way now. So after we're deciding we are going to court, we're going to go to jury selection. And this is more of a Latin term, if I'm not mistaken, voir attorneys for both, and I may have murdered the way you're supposed to say that correctly. It's either French or Latin, but most of our law terms come from Latin. But we'll look it up in a minute. Attorneys for both prosecution, plaintiff, if civil, are allowed to strike a specific number of jurors without justification. So if, let's say me and Mr. Carter Davenport in there are the attorneys for a case of some sort, and that we get a whole list of these jury members that have been summoned to jury duty. We're looking through them, and let's see. Let's say we have a court case about someone destroying someone's property over some political thing. And then you fill out a jury information sheet when you go in. You kind of give them your information so that the lawyers kind of know who you are. So what will happen is me and Carter will sit down and we'll be like, well, I don't want this guy. He was part of this he says he's part of this political party, so I don't want him because he's going to be more upset. We want some neutral people when it comes to that instance. Maybe it happens to be there's a case against a truck driver, and we see that everyone in there's a few people with occupations of truck driver. So we don't want anyone who's going to be biased towards other truck drivers. There's a lot of things that go into it. If you see someone's for the death penalty, then, if you're the defendant, you're going to be like, well, I don't want them at all because I don't want my client to at least not get the death penalty, things like that. And that's what's going to be discussed when the jury is selecting who's going to be on there. So then you go into the opening statements, and both sides will give the opening statement given at the beginning of the trial, sets the basic scene for the jurors by outlining facts and introduce them to the core dispute in the case. So basically the plaintiff and the defendant are going to come forward and say, what is the issue? This is going to be presented by their lawyers, but it's going to be two sides of the story, basically. One thing very important to always remember, and this is just good life advice, there's always three sides to a story. There's the two sides, and then there's the truth. So the jury is really looking for that. What is the truth? There's probably a little bit of truth on both sides, but what you're looking for is that complete truth, and who does that incriminate? So then we go to a testimony declaration by a witness under oath. So there's different testimonies that come forward. It might be the defendant. It might be the plaintiff. It might be people who watched what happened. It might be someone who's a character witness. They didn't have to be there, but they're saying there's no way they did this. Oh goodness, there's something going on in the chat, and I didn't say. Y'all just need to speak up and say something. I don't see the link to the notes on Canvas. Let's see. It should be in the announcements. Let's see. So if you go to announcements and come here, should be right here. Y'all see that? Do y'all see what I'm talking about right here? All right, there we go. Hollinger, are you good now?
Yeah.
Okay, cool. So everyone's good now. Seems.
Yeah.
Okay, cool.
How much did we did I miss a lot of notes? Was there a lot of blanks from what we've gone over so far?
1, 2, 3, 4, 5, 6, 7.
Yeah, I missed some too.
There's like 8 that you've missed.
All right.
I'll go back to it real quick. No worries. We got plenty of time. Where was I at? We're just gonna highlight that. Oh, that works. Yeah, we ain't gotten there. Cool. All right. Real quick, so that's the U.S. Supreme Court. Actually, let me do one thing. Now I can follow along with you. Did I exit out of it completely? I'm a genius. All right, let's see. I'll pull up the fill in the blanks and I can kind of follow along. Okay. There we go. So that is, yes, that is the U.S. Supreme Court. Next one is NC Superior Court. I'll let you get those two. So U.S. Supreme Court, NC Superior Court. The next one is the NC District Court. If I'm moving too fast, just holler out, okay? The next one on that slide with trial procedures is arrest and grand jury. After that, you've got complaint and answer. Oh, complainant. Excuse me, complainant, not just complaint.
They're supposed to be done by date.
I'm not doing that.
I'm so annoyed by it. Like, it's so much legwork to do it this way.
Makes no sense. Sorry, guys, I'm not talking to y'all. No, that makes no sense. So I'm not doing that. Carter, what you need to do, I'm assuming you're on a Chromebook. Mac. Okay. Yeah, you should be able to just make a copy of it. You can honestly probably put it into Google Slides if you need to. But you should be able to hit enable editing or anything like that. I'm not really sure what you're seeing, but you should be able to just like enable editing or something like that. Does that make sense? How do you turn it in? So you are typing in it right now? Okay, cool. Well, when you turn it in, we'll go over that right at the end. So I'll show you where to turn that in. No worries. Is everybody good? Can I go back to where I was, or do I need to?
Yeah, we're good. I'm good.
Okay, cool. If not, speak now. Put some in the chat. All right, let's get back to it then. All right, so we were on testimony. That's going to be read next semester, and I'm going to be like, what in the heck is that about? And I'll never remember what that was about. So evidence presentation, item that can corroborate, I don't know if that was the right word, or refute the testimony of other witnesses. So this is where you start showing, if it's a murder case, here's the firearm. If it's just our cutting our tree down scenario, maybe it's an axe. Usually when it comes to, civil trials, you don't have a lot of evidence. It's going to be a lot of he said, she said, but when it comes to a criminal trial, there's going to be a lot more evidence. It might be records. If it's, possibly someone who was drinking and driving, it might be, their arrest records, what was their blood alcohol level, things like that. And they're going to look into all of those things. So that would be when you present all that evidence. Lastly is the closing arguments. Very similar to the opening statement. The two lawyers are going to give their last pleas, kind of, based off of this evidence. I hope you see that this is why my client is innocent. This is why their innocent's guilty, yada, yada, yada. Basically, their plea to the jury one last time. This is why you should see it my way. And then the jury instructions, so given by the trial judge, that state what the defendant can be found guilty of and what the prosecution or plaintiff has to prove in order for a guilty verdict. So the judge is basically trying to make sure these people understand, because these are just average day people, that, you can't charge them with this. This is the only thing we're looking for. We're charging them with murder. Did they commit murder? You can't charge them with, maybe they did do something illegal and that'll be looked into later, but When it comes to just the murder charge, you know, what has to be found? There has to be, without a doubt, this is it. And all the jurors have to basically agree on that. So moving forward. So the steps to a trial: jury deliberation. Jury is in charge to find defendant guilty or not guilty by all 12 members in the criminal case, by the majority of jurors in a civil trial. So yeah, again, a civil trial is a little bit different. It's not as high stakes because, you know, you're not going to jail for life. Most likely you're paying for something, or you're being told to stop doing something. There's all these different categories, and we're going to get into them actually in the next PowerPoint. What are the actual punishments from either a criminal or a civil trial? And we'll get into actual what is what, you know, defines as a criminal, what's defined as a civil. So verdict / sentence. In a criminal trial, the jury must make a decision beyond a reasonable doubt. In a civil trial, the jury must make a decision by a preponderance of the evidence. It is sometimes called a judgment in a civil trial. So again, like I said, criminal, it has to be without a doubt. You know, I just talked about murder. You've got to understand and know that it was murder, that 100% that John killed Joe, or whoever it was killed the person. And whereas in civil, you know, you're just making that judgment, and it doesn't even have to be a majority of the juror. It just has to be a majority of the jurors and not a all 100% thing. All right, so this is a really good, helpful graphic, and I would definitely suggest going back to it if you ever get confused with the differences. This is easy. This is the federal government. As you can see, it's very easy of how it works. So there's not much time I'm going to spend on that. This one is really good. I'm really happy I found this little, you know, little chart here. So if you look at it from going up, it basically tells you about all the types of courts in North Carolina. There's magistrate, district, superior, and then you get into the NC Court of Appeals and NC Supreme Court. And it also gives you an example of what and why is what goes where in criminal, civil, for both sessions. So magistrate is located across the state, often open 24 hours a day, and in heavily populated areas. A criminal case determines the probable cause for an arrest, accepts guilty pleas of minor infraction crimes, set conditions for petrol release in most cases. In a civil case, these serve as child support hearing officers, perform marriages, ceremonies, hear small claims cases. So these are very small things. These aren't, you know, your big cases. Here you've got criminal cases at the district court, all misdemeanors except those attached to felony incident. So if you murdered someone, it's still going to go up to superior court, which we can see up there. And if, you know, you get a petty theft or something like that, it might go here. But if you murdered someone with petty theft, it's still going to go to superior court. Examples of DWI: larceny of less than $1,000. That's very important to remember. It's less than $1,000, then it's, you know, it's going to go to superior court. And then simple assault. Civil cases involving less than $25,000. Family law, for example, divorce, custody lawsuits for $10,000 for auto crash, something like that. That's a good example. And then we get to superior court. These are all felonies. Misdemeanors appealed from the district court. Examples: murder, robbery, or DWI appealed from the district court. Then you have civil cases. These are cases involving $25,000 or more, and other specialized matters. Examples: $500,000 lawsuit for breach of contract, or a personal injury lawsuit. So these, you know, you're not going to see a lot of civil cases in superior court, and if they are, they're going to be a big deal. They're going to be, you know, they're worth a lot of money because obviously, you know, someone's trying to get over $25,000 from somebody. So then after that, you just, like I said, you got your NC Court of Appeals and the NC Supreme Court, and that's it. So that's the end of that. All right. So let's get done with that. I am recording still, right? Yep, so make sure. So now we're done with the PowerPoint. Once you get done with that, you should be able to go to modules. Let me make sure. I may have messed up, but it should be right in here. If we go to 1.02, it's right here. These are the notes. This is where you turn them in. And you should be able to link a Google Doc even if you did it that way. So you'll just submit that here. It's only 5 points, so not bad. How do we save it? You should just be able to save it like you would anything else. What are you working in, Carter? Like, I'm assuming you have to have downloaded this PowerPoint, correct? Okay, so you're working like inside PowerPoint. Okay, so you're just going to go, let me see. You're just going to hit File, Save As, Browse, put it wherever you need to, and you can save it as whatever you need. So not too big of a deal. Just, you know, save it as whatever kind of document you want to save it. You could probably even save it as a PDF if you really wanted to, but should be pretty easy, and then just submit it. So that's basically it. After you've done that, after you submitted your notes, I would like for you to do activity 1, which is a quiz just like last time. I think it has multiple attempts. Yes, it does. It's worth 10 points. Should be fairly easy. It's true or false. And y'all can just work on that for the rest of the day. That's basically all I've got for you. So, because again, the PowerPoints are taking a lot less time when we're not in class, and I can't, you know, have more discussions with y'all. And there's only 3 of you. So, all right, that's basically it. Are there any questions for me? If not, you know, send me an email later if you need to. I'm going to stop the recording now.